The Mental Capacity Act 2005, how to determine a person's ability to make their own decisions for professionals. The Mental Capacity Act is a law about supporting and protecting vulnerable people who are unable to make their own decisions. It applies to people aged 16 and over and makes clear who can take decisions, in which situations, and how they should go about this. The starting premise will always be that a person has mental capacity. You will need to pay regards to the act in situations where you have a reason to doubt a person's capacity. The law says that before you act on behalf of somebody else, you must demonstrate and evidence reasonable belief that the person lacks capacity to make decisions for themselves. There are two stages to this process. You must first determine if the person has an impairment of or disturbance in the functioning of the mind or brain. This could be caused by anything from an impact of an infection or the use of drugs, through to something much more permanent, such as a dementia. It doesn't have to be a clinical diagnosis, but a statement to describe the type of impairment or disturbance will be necessary. The next step is to establish whether this impairment or disturbance impacts upon their ability to make the decision. You need to assess their ability in the following 4 areas. 1. Can the person understand information about the specific decision? It is really important that you try as hard as possible to help that person understand the information. This should include the nature of the decision and why it is necessary, and the risks and consequences attached to that decision. You need to consider how you provide that information. This could be as simple as making sure they've got their glasses on, writing the information down, or showing them objects or pictures. You may need to consider using an interpreter or speech and language therapist. 2. Can the person retain the information about the specific decision? A person only needs to retain the information long enough to make the decision, so the more complex the decision, the longer the person may need to retain the information to make the decision. 3. Is the person able to weigh up the information as part of their decision-making process? This means that a person really needs to be able to show some insight into the risks and consequences to their health, well-being, and safety in making or not making the decision. 4. Is the person able to communicate their decision to you? This means using any method that is appropriate for that person. Do they need pen and paper? Do they need photographs or objects? If the person is unable to do just one of these things, then you have established a reasonable belief that they lack mental capacity to make that decision themselves. It is important to remember that the Act considers somebody's capacity on a decision-by-decision basis. As the assessor, it is your duty to be clear about the decision you are going to assess, that you have all the relevant information about that decision, and you have thought about how you are going to communicate this information as part of the process. Having assessed someone lacking capacity, the Act provides statutory guidance on how to make this decision in their best interest. It is the law that you follow this process.